Thank you. The CMC hearing is in the matter of case number CFI 033-2022 before His Excellency Justice Nasser and Nasser. The claimants are represented by HFW. Lead counsel is Mr. Matthew Watson. The defendant is represented by Clyde & Co. Lead counsel is Mr. Richard Liddell. Thank you.
Thank you. I believe there was an urgent application filed.
That's correct, Your Honour. I can't see Your Honour, or Mr. Watson. I'm not sure why that is. Does Mr. Watson see me?
I can see both Your Excellency and I can see Mr. Liddell. And I can hear you both, I should add.
And I can see both of you.
Okay, well, I'll just proceed. I can't see you, so apologies for that. Your Honour, this is obviously a case management conference in the Westford set of proceedings, but an application has been filed only just now in relation to a document, and the document was provided by the liquidator of Phoenix. Your Honour, do you have a copy of the application notice which sets out?
I have a copy, but before we proceed to the application, because it's related to a trial that will be held on 16th of October.
Yes, in another set of proceedings.
The defendant wants to use this document in another set of proceedings.
Yes, that's correct.
I have directed the registry to put the application before the trial judge. Yeah.
Well, Your Honour, we made the application today just because, in front of you, because the document has been disclosed in these proceedings, and given the time or the lack of time before the trial and the other set of proceedings, it would be convenient, we suggest, that Your Honour deals with the application so that the document can be used and referred to in the lead up to the hearing.
That's why I have directed for the trial judge, because he is the judge concerned, and it's an evidence to be provided before him. Yeah.
It is, but as I say, it's been disclosed in these proceedings, which is why we thought it would be convenient to try and deal with it today while we have the CMC. But Your Honour, if you'd rather it be dealt with by the trial judge, we will have to make an application to the trial judge.
I have directed the registry to forward it to the trial judge anyways. You don't have to make another application.
Thank you, Your Honour.
Yeah. Unless you want to provide a witness statement to be put forward along with the application before the trial judge, this is up to you.
Well, Your Honour, we under the rules, I think we could include the evidence which we did in the application notice. But Your Honour, I take it that you've said you've directed it to the trial judge, and we'll deal with it that way. What I think we didn't want to do was to somehow fall between two stools, and for the trial judge in the other set of proceedings to say that Your Honour in these proceedings should deal with the application. But I don't think that should happen now if you've directed it to go to the trial judge. So we'll deal with it that way.
Yeah, thank you.
I was going to say, in those circumstances, Your Excellency, the only other thing on the agenda from the claimant's perspective is the draft case management order, which has been agreed by both parties, and Your Excellency will have seen it in section C4 of the bundle.
Yes, I understand that it's agreed by both parties, but the courts,
of course, subject to Your Lordship,
do not agree with the trial date. I think there is a huge gap from today until the trial date. It's 1 year from now, and which can be less than that.
Well, Your Excellency, part of the reason why the timetable has been agreed in the manner that it has is because I understand that Mr. Liddell and his junior and the solicitors that instruct him are acting for Dubai Insurance Company in the trial in which he wishes to use the spreadsheet that's been referred to in the application. And so that legal team are engaged on that trial for a period in October. And so these directions cannot really start until November. And that is why the first date dealing with amendments of statements of case starts in November. And the claimants accept that that means that the trial of their claim is somewhat delayed, but out of courtesy to Mr. Liddell and those who instruct him, we're quite content to have this timetable. And then there is a relatively, in my submission, brisk timetable dealing with pleadings that need to be revised following document production that's been received, agreement of a list of issues, production of documents, witness statements, an opportunity for the parties to adduce expert evidence, and then a trial after the vacation in August. And so I think we would commend this timetable to Your Excellency. We appreciate that there is some delay, but there is a reason for it.
And perhaps I could just add to Mr. Watson's observations in relation to the timetable that it's not just the legal team of the defendant who are going to be in the trial in October. It's also Westford solicitors and my learned friends instructing solicitors HFW who are or will be involved in the trial.
It's okay as of October and November. It's okay when it starts, but I don't want it to end 1 year from now. I want the hearing before that. If it's possible for the parties to review and adjust something before September, it would be much better for the court and for the parties. I think there is a huge gap between each submission. Or the dates in the production of documents. There is like 1.5 months for production of documents. There is 1 month for only witness and 1 month for experts. So if we can shorten the period, I think we will be able to manage something before September and before August as well.
Well, Your Excellency, I'm mindful of the fact that there is likely to be quite a bit of of work to do, and so I would be cautious about shortening. I mean, if Your Excellency, maybe we can go away and see if we can get a date that gives a July trial date, then we may be able to do that. But I suspect rather than going through it line by line in a hearing now, it might be better for Your Honour to allow the parties to discuss offline and try and agree a draft and send it to you.
I don't mind. Yeah. Is the defendant okay with that as well?
Yeah, that seems sensible, Your Excellency.
Then I'll be waiting for the draft.
Well, in which case, there's not. I don't think there's anything further
Yes.
that Your Excellency can deal with at this hearing.
Yes, I agree. Thank you, both parties. We'll be waiting for the draft and then we will decide how we move forward from there.
Thank you.
Thank you, Your Excellency.
Thank you, both parties.